The Uttar Pradesh government implied the Allahabad High Court on 11th of May that it won't concede endorse to indict boss Pastor Yogi Adityanath for his supposedly fiery addresses that prompted collective mobs in Gorakhpur in 2007. The occurrence occurred 10 years back, when Adityanath was the chosen member of parliament from Gorakhpur. He is today the main priest, in the wake of being selected so in March this year. Be that as it may, the question is, would anybody be able to envision an Indian legislator deliberately submitting himself, on the off chance that he has the ability to accept an approach regardless of whether to do as such, to the due lawful process, keeping in mind the end goal to maintain the glory of law? One would need to strain to discover such a case. Demonstrate that government officials from various gatherings, who generally heave venom against each other on open discussions, have met up to guilefully shield each other from the changes of law. The 2007 Uproars episode bears this out. A short history of the case is as per the following. A couple of goons had obviously made trouble with a few young ladies who had been employed to move at a wedding at the neighborhood Deaf College ground in Gorakhpur. After these hooligans were pursued away by the group, they supposedly blended with a Muharram parade which was cruising by. Conflicts resulted, and one Hindu kid, Rajkumar Agrari, kicked the bucket in the fight. Adityanath had purportedly conveyed a fiery discourse when news of Agrari's passing spread. The following day, on 28th of January, 2007, Adityanath, alongside several activists of his Hindu Yuva Vahini, started a walk over the touchy regions of Gorakhpur. Detecting inconvenience, the police captured the MP who was sent to legal authority by the judge. That pushed Gorakhpur into a shared inferno. Many angry Adityanath supporters turned out in the city to dissent his capture. A few mentors of the Mumbai-Gorakhpur Golden Express were supposedly singed by Hindu Yuva Vahini activists. Collective uproars softened out at Gorakhpur, amid which mosques, houses and transports were singed. As per the reports, no less than 10 Muslims lost their lives in the public craze. It was simply after Adityanath was discharged on abandoned 7th of February that regularity come back to the city. Parvaz, a Gorakhpur columnist, was incensed to the point that he looked to document a fur against Adityanath and others. His charge was that the MP had conveyed provocative discourses looking for retribution for Agrari's demise, and this prompted shared uproars. Parvaz additionally asserted that he had recordings of these talks to support his point. Be that as it may, when the police declined to stop a protest, a Samajwadi Party government headed by Mulayam Singh Yadav was in power at the time. Parvaz moved the Allahabad High Court, which requested the recording of a fur against Adityanath and others in September 2008. The High Court's choice was tested by the influenced parties in the Supreme Court, which speedily remained the choice. Be that as it may, in December 2012, the Zenith Court supported the High Court decision and enabled procedures to continue. When the Zenith Court administering came, a Samajwadi Party government was back in power with Akhilesh Yadav as boss pastor. Due to the legal intercession, the case was given over to the wrongdoing branch of the Crime Investigation Department, CBCID, which is an exceptional wing in the CID that researches genuine violations including riots. Addressing the Indian Express, CBCID overseer Chandra Bhushan Upadhyaya, who had examined the case, had this to state: I had finished the examination in 2015. I presented the answer to the CBCID Central Command in Lucknow looking for arraignment authorized to document a charge sheet against 5 denounced including Yogi Adityanath under Section 153N of the Indian Penal Code. But the Akhilesh Yadav government sat over the choice. Bothered, Parvaz documented an application with the Allahabad High Court for the reclamation of the case. The court requested a status report from the administration. The Akhilesh Yadav government reacted that the CID, which was exploring the case, had looked for arraignment endorse from the state government in 2015 and the choice was pending with the Home Division. For a long time, from 2015 to 2017, Akhilesh's administration set the issue aside for later, till prior this year when the SP was tossed out of energy. This was an exemplary instance of trickery from our legislators. Akhilesh wins legentongs against the BJP by and large, and Yogi Adityanath specifically on political stages. In any case, plainly, in the background, he had worked out a comprehension with Adityanath, that he would shield him from indictment for a situation in which, if sentenced, the saffron-clad government official would have arrived in prison for a long time. It just so happens, Adityanath, the prime denounced for the situation, ended up noticeably boss clergyman of the state in March this year. Adityanath's legislature was likewise asked by the Allahabad High Court to react to a comparable inquiry which had been made to the Akhilesh government. Be that as it may, the court was more particular toward its this time. It asked the Uttar Pradesh boss secretary to be available face-to-face on 11th of May, to present the status report of the 2007 Gorakhpur riots case and pass on the administration's choice about the pending instance of endorse for arraignment. Rahul Banerjee, the main secretary, properly told the court that the Home Bureau of the state had taken a choice to deny consent to indict Adityanath and others in the 2007 Gorakhpur riots case. By chance, Yogi Adityanath is the state home clergyman too. Pervez Parwaz, the applicant, has said that he would challenge the administration's turn. He has appealed to the court saying that a prime charged for a situation couldn't be permitted to choose whether he ought to be arraigned for the situation by any stretch of the imagination, as it brings up issues on the value of our equity framework. Be that as it may, Parwaz ought not have much expectation from the legal as courts regularly adhere to the letter as opposed to soul of lawful arrangements. The choice of the Supreme Court in a comparable case in 2007 fortifies this point. A system of prominent natives, similar to Allahabad B.G. Varghese, Kuldip Nair et al. Had appealed to the Summit Court in 2003 that it should coordinate the enrollment of criminal body of evidence against the then boss pastor of Gujarat, Narendra Modi, and Vishwa Hindu Parishad, VHP, pioneer Ashok Singhal, who the solicitors cited confirmation to claim, had made incendiary discourses amid a race rally in Gujarat in 2002. In any case, the Supreme Court in 2007 decided that it couldn't immediate the enrollment of the case without the arraignment authorized from the state government, which is obligatory according to Section 196 of the Criminal Technique Code.